Welcome, class, to our first edition of asynchronous classes for Business Law 1. This is our TC3 Business Law 1 class with me, Kevin Kelly. I'm a lawyer with my practice in Ithaca, New York at flxlaw.com. I encourage you to visit that website and learn more about me and my practice. I'm recording here at my physical office located in the Fulton Meadow building along Route 13 in Ithaca. And that's because this is where the magic happens. All right. I want to give a couple shout outs to Professor Bob Sarakan, who recruited me to start teaching. Also had a lot of help from Malvika Talwar, the assistant provost, and administrative assistants Teresa Mix. And it's my pleasure to share with you my love of the law and my experiences with business law generally as we cover the material in your free virtual textbook, The Legal Environment and Business Law. I'll be posting chapters on Blackboard as we start to cover them, and I record these classes, and we have our live classes on Tuesdays from 10:30 to 11:45. And that book has some authors that I want to give a mention to. Don Mayer from the University of Denver, Daniel Warner from the Western Washington University, George Seidel with the University of Michigan Business School, Jethro K. Lieberman from New York Law School. Last but not least, Alyssa Rose Martino with the Walsh School of Business, and that's brought to you by the creativecommons.org if you want to try to jump ahead in the reading and get those chapters before I unfold them to you in our class. So what is business law? I'm going to start with the definition of business. This is Black's Law Dictionary, which is the generally accepted best source for looking up words as they relate to the law. And it defines business as a commercial enterprise carried on for profit, a particular occupation or employment habitually engaged in for livelihood or gain. So that's where we're going to look at the law from. We're going to study the law from the perspective of being a business person. I hope that's why you're taking the class. A lot of people have been taking it for a prerequisite for being a CPA or in accounting, or moving on to business management, maybe someday going on to get a MBA, Master's in Business. And we're going to talk about the rest of what the law is in the remainder of the class. But first, I want to go over our syllabus. Again, today we're going to do an introduction to the law generally. I'm going to try to, try to focus on as it relates to business, but we're going to approach this class generally what the law is and different topics of the law, and then break it down in the second half of the class. It's going to be pretty much all about contracts. Because if you're engaged in business, that's what it generally comes down to, is those agreements that make business happen, that make commerce happen. So we're gonna do an introduction to law today. I'll record another class about ethics and corporate responsibility in chapter 2. Chapter 3 is gonna cover, give you an introduction to litigation, to what my job is as a lawyer and advocating for my clients who are dealing with business. Then we're gonna take up the Constitution, because that's the foundation, the bedrock of all US law. And we'll have an exam after that. Then we're going to go into administrative law. Oddly enough, it follows the study of the Constitution, but administrative law is not in the Constitution. So that's administrative law, is all the agencies that our government delegates authority to, and it basically covers business more than any other aspect of our lives, I think. Then we're going to talk about criminal law, which is sort of the extreme stakes where as a business person, you can wind up with a criminal record or being incarcerated, not being able to do your line of work if you're a licensed business in a certain industry that requires a license. If you are convicted of something, you could lose your ability to engage in business. So we definitely want to cover those extremes. Then we're going to go into torts in chapter 7, which is sort of the flip side of criminal law. That those are wrongs. Torts are wrongs that you face civil liability for. So you can be sued if you commit a tort, or you can sue someone who commits a tort against you. Then we're going to do a class about the introduction to contracts, and we'll have another exam. And then we're going to move into the second half of the semester covering contracts generally. We'll talk about the beginning of the agreement. There's an offer and acceptance. Every contract requires offer and acceptance, and we'll discuss whether there was actually an agreement that's enforceable by courts, whether there was real assent, the actual agreement, whether there was consideration. Hard for me to get into that just in the introduction here, but there has to be something given in US law to make a contract valid. Then we're going to talk about the legality of a contract, whether it's enforceable, and we're going to have another exam after that. And then we're going to go into form and meaning of contracts, sort of the anatomy of a contract. We're going to talk about the statute of frauds, which generally applies to whether a contract has to be in writing or not, because contracts generally can be done just vocally, or sometimes contracts involve silence we're going to learn about. Then we're going to talk about discharge or ending a contract. And lastly, remedies, which is when there's a breach and what courts do about it. And we're going to sprinkle a lot of that stuff. It's hard to boil it down and just focus on those things. They all depend on each other. So, but I love contracts. They sort of clicked for me in law school, and I hope you have the same experience where all the relationships in your life, whether it's family, people you do business with, with the government. We have a contract with the government. We're going to go over that today, and that's kind of what the law is all about, is a contract between citizens of a state or citizens of the United States, and our relationship with the government and the enforcement of laws. So starting in chapter 1, Introduction to Law and Legal Systems, we're going to first talk about the functions of law, because I think that's the best way to dive into the law generally. What is the law? What does it do? What is it? How is it defined? And we have to look at the functions. So our textbook talks about 6 basic functions that the law, if it's successful, is going to hit all of those functions. And the first, I think about it this way. If we didn't have law, what would society be like? It's generally accepted that without the law, we'd be in chaos. There'd be anarchy, and you wouldn't be able to do business because things wouldn't be predictable. People, would just be subject to whoever was most powerful at a particular time, or the whims of people's behavior. So the first function is peace. If you're a business person, you're going to want peace. If you think about places where you want to do business in the world, when there's chaos or there's disruptions, where there's war or famine, and people aren't observing the law, it's hard to do business in a situation like that. The second function is status quo, which is sort of a Latin phrase for keeping things as they are, because in a way, the best way to do business is when things are predictable, and we can sort of engage in agreements with people when we can predict the outcome. So we don't have a crystal ball, but if things are pretty much peaceful and maintaining the status quo, that's the best environment to do business in. Another function of the law is is to maintain individual rights. So you as a citizen, you have this agreement with the government that as an individual, you'll maintain your rights. And that's something we value in the functions of the government. The next function the book goes into is ensuring the rights of the minority versus the majority, because without laws that protect minorities, then the overwhelming majority can sort of trample on the rights of minorities. The next function is social justice. So what we want to see is the law, or the government in enforcing the laws, maintain social justice, a sense of confidence in our government, in our legal system, that there is going to be justice. And lastly, one thing we can always count on is change. I'm sure you've heard that before, but when it comes to something you can rely on, oddly enough, that's change. Things are going to be changing. And what we want is orderly social change. So, I can't emphasize enough how much the law changes every day. As a lawyer, I find that if I take a break from studying the changes that are happening in the law, I'll fall behind. So, that's an important thing to recognize, and an important function of the law is to keep up with those changes. So the book talks about when those functions sometimes are overlooked by certain types of governments historically. So we can, look at authoritarianism, and, if, a certain government, like look back in history, the Nazis in the end of the 1930s, early 1940s in Germany. And basically, they were very powerful. The government was able to convince people that death camps were a function of the government, and basically that ignored the rights of minorities, obviously. And while it maintained peace for a while, it wasn't sustainable, because that was abhorrent government, that was abhorrent law, and people were, there was a big war over it, and people were brought to justice, and eventually, but obviously one of the tragedies in history that we want to avoid when we're studying the law, and that's why it's important to study that. Another example in the book is colonialism. There still exists to some extent today the remnants of mostly European countries colonizing the rest of the world and just imposing governments on them. And there were, times of peace, but what you had was uninformed governments establishing arbitrary boundaries and ignoring the relationships that people had there. So you had, maybe some peace and stability for a little while, but basically imposing change on populations that the colonizers really knew very little about. So there wasn't orderly social change, and those governments were doomed. So the next topic we're going to cover is law and politics. And I think we'll start by watching a little video about how laws are made. You may have already seen it in grade school, but I think it's always an informative and fun one to watch. So I'm going to go ahead and share that and start playing that.
When school isn't a place you have to be, why not go to school where remote learning can be as remote as you want? These are some plants I found hiking. Here we have a pine. Woo, you sure gotta climb a lot of steps to get to this Capitol building here in Washington. Well, I wonder who that sad little scrap of paper is.
I'm just a bill. Yes, I'm only a bill. And I'm sitting here on Capitol Hill Well, it's a long, long journey to the capital city. It's a long, long wait while I'm sitting in committee. But I know I'll be a law someday. At least I hope and pray that I will. But today I am still just a bill.
Gee, Bill, you certainly have a lot of patience and courage.
Well, I got this far. When I started, I wasn't even a bill. I was just an idea. Some folks back home decided they wanted a law passed, so they called their local congressman, and he said, "You're right, there ought to be a law." Then he sat down and wrote me out and introduced me to Congress, and I became a bill. And I'll remain a bill until they decide to make me a law. I'm just a bill. Yes, I'm only a bill. And I got as far as Capitol Hill. Well, now I'm stuck in committee and I'll sit here and wait while a few key congressmen discuss and debate whether they should let me be a law. How I hope and pray that they will. But today I am still just a bill.
Listen to those congressmen arguing. Is all that discussion and debate about you?
Yeah, I'm one of the lucky ones. Most bills never even get this far. I hope they decide to report on me favorably, otherwise I may die.
Die?
Yeah, die in committee. Oh, but it looks like I'm going to live. Now I go to the House of Representatives and they vote on me.
If they vote yes, what happens?
Then I go to the Senate and the whole thing starts all over again.
Oh, no.
Oh, yes. I'm just a bill. Yes, I'm only a bill. And if they vote for me on Capitol Hill, well, then I'm off to the White House where I'll wait in a line with a lot of other bills for the president to sign. And if he signs me, then I'll be a law. How I hope and pray that he will. But today I am still just a bill.
You mean even if the whole Congress says you should be a law, the president can still say no?
Yes, that's called a veto. If the president vetoes me, I have to go back to Congress and they vote on me again, and by that time you're sold.
By that time, it's very unlikely that you become a law. It's not easy to become a law, is it?
No, but how I hope and pray that I will. But today I am still just a bill. He signed your bill. Now you're a law. Oh, yeah.
Things you should never mix with water. Mascara. Home electronics. Sodium metal. Witches.
Sorry about that. I'm still kind of getting used to recording these classes. But anyway, that's from Schoolhouse Rock, and like I said, you might have seen that in grade school or in high school with the civics class or something. But it's a good starting point to talk about where the law comes from and how the law intersects with politics. So laws come from different sources, and we're going to go into that more in detail as this chapter unfolds. But that particular cartoon shows how laws that are statutes work their way through the legislature and become statutes. And we're going to talk about statutes. There are lots of them behind me. There's statutes. That's what these books are. These little ones. These are New York statutes. And that reminds me, I am licensed to practice in New York State. I'm also admitted to practice in federal court, but I'm not licensed to practice in other states at this point. So, you know, a lot of what I'm teaching and what I'm most familiar with is applicable to New York, and the laws are different in other states to some extent. And we'll go into that more in chapter 3 when we talk about litigation and court systems. But, you know, when the next topic in chapter 1 is how law and politics intersect, and we rely on the legislature and people are voted in. And you know that congressmen or people in the New York State Assembly or the Senate or the New York State Senate and our executives and to some extent judges are influenced by politics. And it's unavoidable in a democracy. But you've got lobbyists, you've got corporations that have money, and it takes money to run for office. You know, people run their campaigns and that all needs fuel, needs money. So it's influenced by corporations, lobbyists, elections, media, news outlets, the way information is dispersed. And that's all affected by politics. Now, I mentioned that, judges to some extent are a legal system, in control of our legal system, in that branch of the government. We try to isolate our legal system from politics as much as possible, because we want the law to be decided as fairly as possible and not influenced by these things. But it's not completely separated from politics. Judges, for the most part, in New York State run for their positions. And sometimes we make those terms for 10 years, which means judges shouldn't be influenced by politics. Other judges at the town and local levels have to run every 4 years. So as a lawyer who practices in front of town court judges, I find that the politics of that area and whether they're running for office sometimes is more important than what the just outcome is in a case. Whereas judges who are appointed or elected every 10 years consider that a bit less. And then judges who are appointed, Supreme Court justices are appointed for life. So the idea there is that the judges are supposed to be completely separated from politics. And we know that's not completely true, because Democratic presidents appoint Democrats and Republican presidents appoint Republicans. And we end up with a political divide on our Supreme Court, for example. And, it's hard to separate the law from politics completely. And in real life, as a practitioner, I have to sort of look at a case with that prism, looking at what the law is, but how politics can affect it. So it's just something to keep in mind, that, lawyers have to consider that. It's somewhat unfortunate, or maybe it's good for your case. It's reality. So another thing that we look at in this part of the chapter is what we call non-governmental administrations, or NGOs. And those are organizations that are not part of the government, but they have political influence over the law and how it is implemented. So, for example, the National Rifle Association, or the NRA, not part of the government. They're an organization that people donate money to. They have membership benefits, and they're there to protect people's rights to own a weapon under the Second Amendment to the Constitution. That's what they're devoted to. Or we've got the Red Cross, which is an international NGO, and they're dedicated to helping world health, basically, making sure that people recover from injuries and fight disease, and they do the best they can. And they do have some influence over governments, for example, fighting HIV, or making sure there's enough blood for people who need blood transfusions. But non-governmental organizations influence the law, and business law in particular. All right, moving on to schools of legal thought, or philosophies of law, also known as jurisprudence. And the first one we're going to focus on is legal positivism. Most of the material in this book is sort of observing that school of thought, and that is that law basically comes from power or command, and think of the unwritten laws. I like to say a lot of law is asking the questions, who's going to stop me? Or what are you going to do about it? So let's use the example in the book of the posted speed limit. All right, so along Route 13 between Ithaca and TC3, you've got, of course, 30 miles an hour when you're driving through the city of Ithaca, and then it gradually rises and you go to 55 miles an hour, and then it goes back down to 45 miles an hour, and then it goes back to 55, and when you get to Dryden, it goes down to 30. And what is the speed limit? Well, it's posted there. Everybody should know what it is in those different spots: 30 miles an hour, 55, 45, etc. Where it's 55, though, a lot of people are going to be driving 60 miles an hour, maybe 65. And I can tell you, as a lawyer, I haven't seen many speeding tickets that are less than 10 miles over the speed limit. So I think a lot of people recognize that there's a buffer zone there. And what we see in play is legal positivism. It's basically how people are behaving, and sort of law coming from a source that we can't put a finger on, and that's command and power. And if you've got the majority of people going 5 miles over the speed limit, then the speed limit's actually more like 60, or if they're going 10 over, it's more like 65 when it's posted that the maximum is 55. Rarely are people driving less than the maximum on roads, it seems like. And rarely are people getting tickets for going just a little bit over the maximum. Another unfortunate example of how legal positivism works is, again, we bring up the example of the Nazis in Germany and going into World War II. And basically, Hitler thought, and a lot of people supported him, that death camps were a good thing in the law. And, basically, if you just stick to this school of law, if you only observe legal positivism, then they had a legitimate role. It was a legitimate use of the government to have these death camps, which in hindsight is absurd and offensive, to say the least. And then if you also think of, civil disobedience, we're going to segue into the next school of thought. If you think of sort of Rosa Parks and the history of segregation in our country, and Rosa Parks said, "You know what? Who's going to stop me? I'm gonna sit in the front of the bus." And basically, by taking that stand, she was able to be a hero in changing and getting rid of segregation in our country. So, but that segues into natural law. And I think there's a balance between these two schools of thought schools of law throughout our study of business law. So if you think of me being like the scales of justice, you're going to have legal positivism on one hand, and we can't really deny that law comes from power, it comes from command, it comes from the law of numbers, and use of force, who has the ability to enforce the law. And then on the other hand, we have natural law, which is a theory that the law comes from a universal moral order, or sort of the struggle between good and evil, and good always winning. So the book kind of suggests that we're going to favor legal positivism. So we're going to kind of look at it from that angle, from that school, but we're heavily considering natural law, which is on the other side, that the law comes from a universal moral order. And there's a strong history of natural law with the United States. The book brings up the example of the Declaration of Independence. And basically, we've got our forefathers saying, we're done with being controlled by England. We're not colonies anymore. And on July 4th of 1776, we've got the Declaration of Independence. And in that document, I'll quote, "We hold these truths to be self-evident that all men are created equal." And sort of our forefathers believed that if they respect this natural law, that they're motivated to do something different than the way the British government was colonizing them. And that was, a fight between legal positivism. The British Army and Navy and the forces back then were the strongest thing, so they were able to colonize us. And then we said, you know what, we're done with it. There's a balance, though, between legal positivism and natural law. So it wasn't just these powerful words that were in the Declaration of Independence. If you study the Revolutionary War, there were logistical problems with Great Britain keeping control over so many colonies around the world. And, basically the United States called their bluff on that. And that's, I think, another reason why we were successful. But it was not an easy thing by any means. And I think that being motivated by natural law and people believing that it was a struggle between good and evil was what kept us in the fight and ultimately won. But that's going a bit into history. Again, going back to civil disobedience, there's a lot of language from studying Martin Luther King, Dr. Martin Luther King, for example, and his speeches often have language in there that sort of adheres to the School of Natural Law. Having in his letter from the Birmingham jail, he was engaged in civil disobedience to the extent that he was incarcerated. And he had wrote that actually civil disobedience, while it's breaking the law, actually demonstrates the highest respect for the law. And I think that, there's a lot of examples in history where civil disobedience was an effective way to change the laws, including the end of segregation, as is brought up in chapter 1. All right, there are a lot of other schools of legal thought, and we're not going to go into them too much, but some examples in the book that they touch on is sort of historical study of the law and looking at valuing sort of experiences that are learned from the past, and that being the main prism of looking at the law. Another one is the legal realist school, which basically focuses on social context to law and how they evolve. There's critical legal studies, and that sort of led to Marxism, for example, and looking at the law and how it's always been the haves and the have-nots, and how inevitably that's going to lead to chaos. That balance can't exist for a long time, and then the answer would be socialism in that school. You follow it to its core. But the way the book and the way I'll approach the study of business law is that there's a balance between these schools. Okay, but the basic concept of U.S. positive law we're going to cover now. And the first concept is moral minimums. So a successful legal system or a successful government implementing a successful legal system is going to involve moral minimums, because a government can't correct every wrong out there. It's just an unattainable standard if we're going to expect our legal system or the government to protect every wrong. And, people do wrong things all the time. I mean, an example in the book is, it's probably wrong if your friend calls you and leaves you a message and asks to call them back, and you neglect to do that. That's wrong, but it's not illegal. It's not something you're going to face a penalty for generally. Now, there are times when that could be the basis for a lawsuit, but we'll get into that later. But basically, not every wrong is going to be corrected. And I brought up the example in the book, brought up the example of speeding, for example. And basically, there's not enough police, there's not enough resources in our legal system to punish every person who goes a mile over the speed limit. So what we do is we pick and choose the most offensive, and we create an example, and we achieve moral minimums. So that's the example there. Let's see. And the idea there is that, it's enough to protect us, citizens, society, from anarchy and chaos. So that's sort of why we look at moral minimums as the goal. and to create an environment where you can do business. So, you know, the Department of Health, for example, if you have a restaurant, or the Environmental Protection Agency, I mean, they can't watch everybody at all times. So they sort of show up unannounced or show up certain times of the year, and that's how the laws are enforced. Or if you have a vehicle and you have to get it inspected once a year, well, that's sort of the minimum of what we can do. We can't make everyone go get their car inspected every day or every month. We've decided that once a year is the reasonable way to enforce moral minimums. All right, the next concept in chapter 1 has to do with what we call common law and the concept of stare decisis. That's a very important Latin term that basically means let the decision stand. Okay, so when judges are doing their job and they're deciding how to decide, or when they're deliberating how to decide a case, they don't just go on a whim and decide what they feel like, you know, what they feel is just. They actually go to these books over here that contain precedents, okay, and they apply old cases that have already been decided by higher courts, and they apply that law to the case in front of them. And that's called the concept of precedent. Also, the Latin term stare decisis, meaning let the decision stand. And that's where common law comes from. When I talk about common law, that, to just make a distinction, that's different than a statute. I talked about statutes. Those are the laws where you actually pass a bill, like we watched the cartoon about, and that creates a statute. In that video, I believe the statute was a law that requires all school buses to stop before a railroad. And basically what happened was people saw a problem, I guess there was a horrible tragedy where a train ran into a bus, and someone said there ought to be a law that all buses have to stop and listen for trains. And that'll prevent, even though it might seem silly, it might be inconvenient for traffic, but at least it prevents such a tragedy, like a whole school bus of children being blown up, stops that from happening. And that law passed. And that's why if you're driving behind a bus and you approach a railroad, you don't have to stop for every railroad crossing, but buses do. And so that's what a statute is. And that's different from the law that I'm talking about now, which is common law and precedent and stare decisis. That's law that comes from judges, and it is published in decisions, and lawyers look at those decisions and they apply them to cases that are in front of them, and they can predict to our clients, we can say, well, there's a precedent because the Supreme Court decided that, you know, you can't discriminate, for example. So, that's a precedent. It could have its origins in a statute, but then statutes are kind of vague, and sometimes there's a lot of gray area. And what the courts do is they take those statutes and they apply common law to when they decide cases in courts. So 3 topics of common law that we want to distinguish. The first one is property law, and that has to do with real estate or certain tangible things that are property. And when it comes to real estate, generally, we are going to talk about that stuff, but it's not going to have its own chapter. If you continue on to business law 2, there's topics involving title to property, whether the ownership of property is established and clear, but we're not going to go into that too much in business law 1. But we are going to talk about here and there deals that have to do with real estate. So we're definitely going to cover that when it comes to contracts. The second category is torts. I talked about that a little bit when I was talking about the syllabus, and that has to do with harms or injuries that aren't criminal and when there's not a contract. So think of someone slipping and falling at a grocery store. There's not a contract there, but there's a duty of the grocery store to protect the customers from slipping and falling. So that would be a tort. It would be a lawsuit against a grocery store if someone slipped and fell. Or think about an automobile accident. there's no business contract or any type of contract between two vehicles, but we have sort of a social contract not to be negligent, not to harm people, and so that can result in a lawsuit, and those are called torts. We're going to cover those in chapter 7 more. And then contracts, and I told you that the entire second half of this course is devoted to contracts and the different things that go into making a contract, and what happens when someone breaches a contract, and what kind of remedies are available if someone in our legal system, if someone breaches a contract. So common law applies very heavily to those 3 topics. And when you think about this isn't really in the book, but it's something that I think is important to understand. Common law and stare decisis and precedent, and how it developed in history. The ability to refer to old cases, to precedents, how things were decided by other judges, and how that's binding on courts. It really developed, I think, as we're able to keep track, as we're able to record precedents. So I think of the history of paper, and paper was first developed under the Han Dynasty in China between about 25 and the year 220 AD. And so it worked its way, west across the Islamic governments, and we saw evidence of them developing the use of paper in the 8th century, and by the 11th century it made its way to Europe. And of course we know that the printing press was developed around the year 1440. So as a lawyer, I look back and look at the history of how precedent and common law developed, and it goes along with the way we're able to record things and the progress of developing paper and printing press. And that's why lawyers are able to refer to precedents, have these books in their offices, and tell their clients how the law is developing. These books, by the way, are updated every year. So when I have a subscription to one of these books, what'll happen is they're updated with the new cases as they develop. So you've got the main book, and then at the end, there's a supplement which gives us updates about the progress, the changes in the law that the courts are giving us. So, this book here has to do with surrogates court, which applies to when people die and their estate is divided up. And, this book is the 2020 edition, but look, already there's been some updates to that I've received from the publisher. Now that's old-fashioned law. Most of what I do when I do research is on the computer these days. So I have a subscription to various publishers. They used to publish these books, and now they have online, which is just easier to use if you're computer literate. So a lot of older attorneys stick to these books. And then there are certain topics, like I have the surrogates court one where I do a lot of that work, or this one here is criminal law. This is the 2021 edition of Gilbert's, and it's a combination of statutes and also the way the statutes are applied. It gives me notes about the most seminal cases when I'm dealing with a particular topic. So it's sort of a mix of those statutes and precedent, or stare decisis. That's what's, court decisions that's contained in this book. And since I do a lot of it, and I'm familiar with these books and I want to carry them around, I might not have internet access all the time. So it's, in topics that I cover a lot, I will invest in these books and use both the computer and the books. All right, we're going to be visiting these concepts a lot throughout the rest of the course. But for purposes of chapter 1, I want to move on to some distinctions that are covered by Chapter 1, we've got state law versus federal law. So I told you earlier that I can practice in New York State, so I can practice in any state law, but I'm also sworn into practice in federal court. And there's a whole different set of laws for each of them. If you think of, federalism, maybe you learned about this hopefully in grade school and high school, and that is the cooperation between our state government and our state legal system in New York and the federal government. Certain kinds of law can go to either court, and we're going to really get more into this in chapter 3, but just for purposes of an introduction, we've got the federal system, which has exclusive authority, or we're going to learn about, we're going to call jurisdiction, over certain types of cases that apply to business. Think about commerce. So if we're talking about disputes or issues that happen all over the country, your business may be in New York State. If it's interacting with a business in Florida, well, we're talking about federal jurisdiction or the federal court system, perhaps. The state, I want you to think about maybe more domestic matters. So issues like divorce. Rarely, if ever, is a divorce going to end up in the United States Supreme Court, because there's really just no federal issue there. But basically, there's a nice equilibrium that changes. I say there's a trend toward things being more federal historically. There's a trend toward that. The federal government's growing. We started with 13 colonies. They experimented with the Articles of Confederation. That didn't work. So we had a constitution that recognizes federalism better, and that there's a sort of a balance between states' rights and state jurisdiction and the federal government. And, we'll be studying that more in chapter 3. Another distinction, which we want to make sure we understand early in the course, is the difference between civil law and criminal law. I showed you my criminal law book there. The criminal work that I do, the stakes are very high. People can be incarcerated. It ruins their life if they're convicted of a crime. And as a business person, if you're convicted of a crime, it's going to be very hard to do business after that. And, that's, we're going to cover that in chapter 6 exclusively. But there's sort of a spectrum of things that can go wrong in business. And, I talked about torts. Someone can slip and fall at your place of business and you get sued. You lose some money. Hopefully you're insured, and that's why we have insurance. But, if you maybe do something like misappropriate money, that can be a crime. It can be a felony. You could go to state prison for that. So there's a difference between civil law and criminal law, and that's the greatest distinction I can think of right now. You've got another, we'll cover in chapter 5, administrative law. So there's sort of policing agencies like the Occupational Safety Health Act. OSHA establishes that administration, and they try to prevent pollution and stuff, or also and they protect workers from that kind of thing. Then we've got the Environmental Protection Agency. Those are kind of like police, especially if you think of the DEC, the Department of Environmental Protection. Different agencies sort of have somewhat deputized officers, but and they cross over sometimes into criminal law. So certain types of things, if you're polluting, for example, it can be so offensive to society that there's a law making polluting a criminal offense, not just a civil offense. But basically, if you think of the difference, we've got civil, which is having, you're not really going to jail, but you might have to pay a fine, versus criminal, where you can end up in prison. And then we're going to see that distinction again in chapter 3. We're going to learn about the court systems. And there's different tracks for civil cases and criminal cases, but we'll get into that more, there's a nice table on page 13 of your textbook, table 1.1, which sort of spells out for you the differences between civil and criminal. And these distinctions, by the way, are easy to touch on for me. So this is a topic you should pay particular attention to. The next distinction is substantive law versus procedural law. So substantive law is those laws that spell out what is maybe wrong, to what degree things are wrong. And procedural law sort of gives us how the law is implemented. So there's a nice list on page 14, but talking about substantive law, for example, in talking about criminal law, it's easy for me to make the distinction there. You've got the law that stealing anything over $1,000 is grand larceny. Okay, so there's different degrees of larceny, different degrees of stealing. And grand larceny, easy to remember, grand means 1,000, that's another word for it. So we call grand larceny, that's going to be a felony. And the substantive law about that is you can go to state prison on a felony. It can prevent you from having certain jobs. Whereas stealing less than $1,000, we call it petty larceny. That is punishable by up to a year in jail, and it's a misdemeanor offense. So, the substantive law about what's a felony and what's a misdemeanor and the different degrees of offenses, that's a good example of substantive law. Then procedural law, on the other hand, is how the law is implemented. So, for example, are you entitled to an attorney if you're accused of a crime? And the answer is yes. You're entitled to an attorney if you're charged with a crime. But if you're charged with a civil offense like speeding, you're not entitled to an attorney. Or we'll talk about the statute of limitations, which is an important concept. As a business person, you want to understand that you have time limits to file a lawsuit, for example. And generally, for a negligence claim, that's going to be 3 years. So after someone slips and falls in your business, you got to worry about it for 3 years. But after 3 years, it's going to be too late for someone to sue you. That law is called the statute of limitations, and that's a procedural law. Another one is if you take a case to trial and you lose, you have 30 days to start your appeal. And so that's a procedural law that you have to keep in mind. If you can't just a year later be upset about losing a lawsuit, you have to start that appeal within 30 days. That law is procedural as opposed to substantive law, which covers more substance. All right, moving on to sources of law and their priority. So we've got the Constitution. Okay, we the people, and we have the oldest Constitution that's still being used as law in the United States. I didn't actually know that fact until I started teaching this course, but that's an interesting one to know, that the United States has the oldest Constitution that's being used. And that's the bedrock or the foundation or the framework that all other law comes from generally. That's the way you got to look at it. So it has the most priority. Then we've got statutes and agency regulations. And we talked about statutes and how they get started. We watched that cartoon, that's a statute. And then there's regulations that come from agencies that I talked about, like OSHA or the EPA or the DEC. And those are kind of grouped together. Those are below the Constitution. So you always start with the Constitution as far as priority. And then there's statutes. And then there's those judicial decisions that I talked about, or stare decisis, precedent, common law. Okay, so that's interpreting those things, including the Constitution and then those statutes. And every day the law changes, new decisions come out. I got to stay on top of them as a lawyer, and as a business person, you should at least try to be on top of them as much as you can, or have a good lawyer who stays on top of it. All right, that's generally the priority. It goes, chapter 1.4 goes a little bit more into detail, and it talks about the Constitution. It talks about federal statutes and treaties in Congress. So when we talk about the federal Congress, we're talking about 2 houses, the Senate, which is 2 senators from each state, and then 435 members of the House. And, the House, depending on the population of the state, each state gets a certain amount of representatives in the House, and that's based on their population. And the population is kept track of by the census every 10 years, and then it appropriates the amount of representatives in the House, and that's been 435 since the last time it was established in 1929. So that's still what we got today. Let's see. It might seem a little odd that no matter what, you can be this little Delaware, Rhode Island, or Wyoming where it's just not very populated, and you still get 2 senators no matter what. And then a state like California could have the most representatives in the House, but they still only get 2 senators. And that might not make a lot of sense to people, especially if you're in one of those populated states. We're in New York and we only get 2 senators, and then a state like Wyoming that doesn't have a lot of people, they still get 2. And it can seem frustrating sometimes if you're from a populated state, but hey, that is the compromise that's working. We have the oldest Constitution, and I sincerely believe that while the government's not perfect, while the legal system's definitely not perfect here, I believe it's the best in the world, and it's the best in history. So that's pretty good. I'm happy to be part of it, and I think it's generally changing for the better as we change. It's generally going in the right direction. But the next kind of law I brought up, we're going to cover in chapter 5 more. I've been talking about it a little bit, but that has to do with the law that is delegated to agencies, or administrative law, that we'll be covering in chapter 5. Again, think the Environmental Protection Agency, or the DEC, or OSHA. And those, they're not in the Constitution. However, there's been enough support over the years that it's a growing field of law. Our government delegates enforcement of certain laws to agencies. And if you think about it, it does make sense. I mean, we can't have politicians enforcing every law. Politicians don't necessarily know the science about what kind of chemical is most polluting, so we rely on scientists for that. And those administrative agencies are going to hire those scientists, and they're going to stay in office, and they're going to be isolated from politics. At least that's the goal. And you can see the value to that as it protects citizens in enforcing the law. All right, then it talks about state statutes and agencies. So we've got those federal laws, and then we've got state laws and state agencies. Those are on a lower priority. In federalism, if there's a federal law about something, it sort of trumps a state law that might conflict with it. But certainly states can make laws that are different from state to state. There's a couple examples in the book. There's one that is particularly troublesome to me, a law in the town of Eureka, Nevada, where it is illegal for a man with a mustache to kiss a woman. I mean, come on, what kind of law is that? Now, I did a little research about it, and it's not enforced, of course, but those laws are on the books, and we'll get more into the efficacy of laws and the study of it, and as we go into chapter 2 with ethics and the sort of study of which laws are important, why they're important, whether they should be enforced, and how they should be enforced. So again, coming back to the topic of judicial decisions, common law, or stare decisis, being precedents that are enforceable in United States law. Now, at the end of this chapter, we're going to talk a little bit about how that is somewhat unique to United States law. But that's where this book and this class are going to focus on generally U.S. law. We're going to talk about some exceptions, ones that are very common in international law as they relate to business. So you'll know some of those things. It is very common in other countries to follow precedents, but there, some don't follow that as much as we do. All right, so I talked about priority. We've got the Constitution being the preemptive force in US law, the bedrock, the foundation, if you will. We've got statutes and cases. We've got treaties as statutes. So a concept that's introduced here that I want to talk about has to do with treaties being agreements with other countries, which only the federal government can do. States aren't supposed to make agreements with other countries, because when we're dealing with other countries, we're basically saying that's the federal government, that's not the state's duty. But what happens when a treaty is inconsistent with a law, whether that be state or federal? And if, generally the rule is last in time. So the example in the book is is a law called the Marine Mammal Protection Act of 1972. And what you had fisheries going out and getting tuna. And the method that they used was to take out a big fishing boat, send out a little boat that would put a net to cover a huge area where there was a school of tuna, and just to bring up all the tuna and everything that would get caught in the net. And the troubling thing about that was there were a lot of dolphins that were feeding on the tuna, and they died, even though the fisheries weren't trying to catch those dolphins, weren't using them, and basically the dolphins were wasted, their lives were wasted, and people thought that was cruel and it wasn't necessary. So they made this law in 1972 that said, we are not going to import tuna from international companies that use that method of fishing. And that went along for a while, that what we called an embargo, a law that says we're not going to import. And so that went along for a while, except that we joined into a couple of treaties. There was the GATT agreement, and eventually the establishment of the World Trade Organization, which basically said that we're agreeing to allow importation of tuna despite those practices. And that conflict is a good example of where we actually could not enforce the Marine Mammal Protection Act of 1972 because we had a treaty that we would operate business a certain way. So we're bound by that treaty, which came later. And the Marine Mammal Protection Act was ruled not to be valid. And we lost that lawsuit at the World Trade Organization. All right, now the next concept we're going to talk about are causes of action. So going back to the idea of moral minimums, just because you feel wronged about something doesn't mean you can file a lawsuit and win, doesn't mean you can call the police and get someone arrested. You have to have what's called a cause of action. So lawyers, when someone comes into my office and they're upset about something, that's what I'm looking for. I'm looking for a cause of action. In other words, is there a law that protects my client from a particular wrong? Or, is my client accused of something where there is actually a cause of action, or can I get it dismissed because there's not a cause of action? So an example in the book is, let's say you sold 76 trombones to someone by the name of Harold Hill, and Harold Hill refuses to pay you for your 76 trombones. Do you have a cause of action? Generally, yes. You had a contract, you provided the 76 trombones, you were supposed to get money for it, and you didn't get it. So that's going to be a cause of action generally. However, there are some exceptions to that. So for example, if Harold Hill was less than 18 years old, the law with contracts is that you have to be age of the majority. You have to be over 18 years old to engage in a contract. And there's exceptions to that, but as a general rule with business, you don't want to do business with people who are less than 18. Now, obviously, if you own a store and someone buys food, that's an enforceable contract. But if you sold 76 trombones to someone who's under 18, you engage in a contract, that contract can be voided by the person who's under 18. Or let's say Harold Hill actually requested trumpets and you delivered trombones. Well, you didn't fulfill your end of the contract. There's not a cause of action there. Or let's say Harold Hill said, I needed those 76 trombones for the 4th of July party, and you delivered them on the 5th of July. They're useless to me. So then you wouldn't have a cause of action under those circumstances. Another example is, let's say you get stood up for a date. You go on Tinder and you have a date, Netflix and chill, and someone doesn't show up and you're upset about that. But there's not a cause of action under those circumstances. However, let's say you had an agreement to be married to someone and they decided not to show up for the wedding. Well, historically, there was actually a cause of action for that kind of thing. Now, those laws are antiquated. They're disappearing. There's not really a cause of action because we're evolving as a society. We're saying if someone doesn't want to get married, then it's better that they don't get married because we're going to have to deal with the ugly divorce later, perhaps. But we'll get into more of that later. So generally, there's not a cause of it. That's an evolution of the law. There's not a cause of action for that. And now I want to talk to you a little bit about how precedent works in more detail. So that's a lot of my job as a lawyer. When someone comes in and they got a case, what I do is I do some research and see what the precedent is. And I may argue that their case fits a precedent. Or I can argue that it doesn't fit. If the other lawyer on the other side is saying that it fits, I'm going to say it doesn't. I can distinguish my facts from the precedent and ask for a different outcome. So that's a lot of what I'm dealing with. And it helps you understand the importance of a written decision. So at the end of this chapter, we're going to talk about a written decision from the United States Supreme Court, Harris v. Forklift. And in the United States court system, as a lawyer, I'm always reading these cases and seeing how they apply to the cases that come to my office, that come to my practice. So we'll get into that and hopefully you'll understand how that works a bit better. All right. The last topic in chapter 1 before we get to that case has to do with world legal and political systems. And it's pretty brief, and I'm not going to test a whole lot on this topic because I don't think the book does a good job of explaining it, and maybe that's for the best as we focus on US law. And if you're going to practice international law, then you're going to have to go into this topic more. But basically, we inherited our system of common law from Great Britain because that's where they were going at that time. And that's what we inherited, which makes a lot of sense. If the government that we broke away from was Great Britain, then it makes sense that we inherited a lot of those things. However, the book gives examples of Roman or Napoleonic codes, which give judges in legal disputes more flexibility, and they don't have to stick to a precedent. So they sort of go to this code and try to observe the code more than precedents. So, that would be a different approach to the law if I was in another country where they had a code. And I would certainly want to have local counsel there. I'd want to have an attorney who was used to doing that kind of law. The other thing the book goes into is maybe communist countries. So Cuba or North Korea are going to have different values in their court systems that adjust for Marxist philosophy that we don't observe in the United States. We're more of a capitalist country. it's very inherent in our Constitution and in our legal system that we promote business. We sort of have a hands-off approach from the government, at least. And again, there's a balance there. You know, there's always the sort of the capitalist values that are maintained in the Constitution, and then there's sort of limits to that, and there's a zigzag of in history how those things are valued by our legal system. All right, and then it also mentions Islamic society. So, you know, if I found myself in Iran, for example, the law is just going to be very different. You know, precedent might not be as valued as maybe looking at a government, a legal system that's heavily influenced by that religion. All right, so our sample case at the end of chapter 1 is Harris v. Forklift, and a little introduction to that. It's a case from 1992, and it has to do with Title VII, a federal statute protecting people from various discrimination in the workplace. And I want you to think about if you've had to take, in New York State, we have mandatory sexual harassment prevention training, and that's required by employers to make sure their employees get that training once a year. That's a recent development in New York State law. And if you're paying attention, they teach that there's basically 2 kinds of sexual harassment. And the first one is called quid pro quo, or this for that. And we're going to see that phrase, that Latin phrase, a lot in the rest of our study of business law, because contracts are quid pro quo, this for that. And this type of sexual harassment basically means that an employer or someone, a boss over a subordinate, offers to exchange a sexual favor or performance for a raise or a promotion. And that would be sort of the worst kind of sexual harassment that our law recognizes. And that existed prior to this case in 1992 at the federal level. The other kind of sexual harassment, called a hostile working environment, is a little bit more subtle. So, and that's what we focus on in the training, because it's obvious if a boss makes a proposition like that, this for that, that's obviously sexual harassment, and someone's going to get sued for that. But it's a little more subtle, and I think it's evolving. It's changing in the right direction with what we see in this 1992 case. The case was unanimous by the Supreme Court. In other words, all of the judges agreed that Teresa Harris was the victim of sexual harassment in this case. And the case involved her boss sort of speaking innuendos about her and other fellow female employees about their clothing. He would throw objects on the floor and tell them to bend over to pick it up. He would tell them to get coins from his front pants pocket. He would say things to Teresa Harris when she wanted a raise. He would say, well, let's go to the Holiday Inn to negotiate your raise, which obviously was implying that she should get intimate with him in order to convince him to get a raise. He called her a dumbass woman. He said in front of other people, you're a woman, what do you know? So those were well-documented things that happened, but it wasn't quite quid pro quo. So it's a hostile working environment. And the precedent from 1986 from the Supreme Court was a case decided, Meritor Savings versus FSB Windsor. Meritor Savings FSB versus Windsor. And what the Supreme Court decided in that case was that for a hostile working environment to be a cause of action, for it to be a proper lawsuit, not get dismissed, for it to have that moral minimum that the court's going to address, the language they had was it had to seriously affect the plaintiff's psychological well-being or lead them to suffer an injury. And at the lower court, it was decided that there was no injury. Teresa Harris is, she left her job voluntarily. And under common law, it's generally accepted that the employment relationship is at will. In other words, there's no contract, unless there is a contract, but there's no contract under common law. You can hire someone, you can fire someone, you can start working at a job, you can leave that job. There's not a mechanism in common law where there's a cause of action for that. But this case recognized that behavior by Teresa Harris's boss, while it didn't create some kind of injury, she didn't have a nervous breakdown and have to go to the psych ward, but she shouldn't have to put up with that. That's a hostile working environment. So that law created this precedent. And since 1992, we've been going in the right direction when it comes to sexual harassment in the workplace. And there's, I like to believe, a good change in the law that we're going toward that. And if you're a business person, you're going to be responsible for making sure that all your employees are aware of that. And you have to provide that training. All right, well, that just about wraps up chapter 1. But I do want to just talk about one more topic, and that is the idea of a social contract. So we've basically been talking about tiptoeing around it, but when this case is going to end with contracts, I want to make sure I bring it up early in the course in the introduction to the law, that I want you to think about a contract between citizens and our government. So we agree to sacrifice some of our freedoms in exchange for the protections that our government, our legal system gives us. So those 6 functions at the beginning of chapter 1, in order to have those 6 functions to protect us as citizens and as business people, we have a contract with the government that will abide by the law. And there's a quid pro quo there, and there's a social contract that I want you to keep in mind as we study business law. All right, that covers chapter 1, and I look forward to studying chapter 2 with ethics and corporate responsibility.